When is child support awarded during the divorce process, or if parents are not raising the child together in North Carolina? Attorney Elliot Duggar explains. Custody and divorce are separate legal matters in North Carolina to the following extent. Any parent can file for custody and a child support order if they are separated, divorced, or never married. In North Carolina, most parents will be required to attend mediation prior to going to court over custody, unless a proper waiver is granted by the court. Required mediation in North Carolina may be established by local court rule or by individual court order. In both states, the exceptions or waivers depend on certain past behaviors of the parties. To make an action against another parent in North Carolina, the parent who takes the action must have lived in the state for at least 6 months. Additionally, there is an interstate compact regarding where the jurisdiction lies depending on where the child has lived for the last 6 months. States generally agree that if the child has been living in a certain state for 6 months or longer, the court will defer to that jurisdiction. There are emergency provisions in place to determine jurisdiction if there is ever a question about it. For instance, say a child lived in North Carolina for 7 years, then moved to Oregon to live with his dad. If they have been in Oregon for 6 months or longer and their mother has not yet filed anything, when she files in North Carolina, the other spouse will hire an attorney in Oregon. From there, the judge in Oregon and the judge in North Carolina will confer about the case, but the jurisdiction will ultimately be in Oregon because the child has been there for 6 months or longer. In this situation, the court case will eventually be moved to Oregon, unless there's some exception. It's worth noting that you will not receive child support until you ask for it. This can be done between the parties by stipulation or in accordance with the North Carolina child support guidelines. If there is a dispute, this is settled in court, which takes place right away. If there is a difficult parent that refuses to pay child support, the recourse would be to file immediately during the separation period in order to gain financial support via legal means as quickly as possible. Whether you need support with a family law matter, estate planning goal, or something in between, Duggar Law Firm is here to help. We offer the resources, support, and experience necessary to get the job done right the first time. So, call us now or visit our website at www.duggarlawfirm.com.